Good morning. A brief reminder that unless the court has put down an order otherwise, the oral arguments will be streamed live on the AOC's YouTube site, and then will later be posted to it. So whatever we say here today, I guess, lives forever. Call the first case, please.
Susan Anderson, by her conservator, Rebecca Woods, et al., v. Alexian Village of Tennessee.
Hear from the appellant when you're ready.
Michael Thomas for the appellant, Your Honors, from the Hamilton County Bar. I beg your forgiveness, I'm a little under the weather this morning. I have a doctor's appointment this afternoon. It's not anything contagious, but it's certainly taking me down pretty hard. So if I pause from time to time, chances are I'm just trying to catch my breath. So please,
that's fine. That's fine.
Please forgive me.
Not a problem.
Thank you. Once again, Michael Thomas representing the plaintiff in this matter. Your Honors, this case involves...
Counsel, you want to reserve any time for rebuttal?
4 minutes, Your Honors.
4 minutes.
Thank you.
Thank you.
Case is boiled down to its basic, essentially involves issues with Section 121 in the notice letter that is provided in prior to filing suit. In this case, 121 letter was timely sent, and a 121 letter was attached to the complaint. The issues with the complaint are that, first, the original letter that was signed and sent to the defendant was not photocopied. However, the existing document still existed in Word format, word for word. It's undisputed that the notice that was received and the notice that was attached was word for word the same, with 2 exceptions. One, the notice that was printed had an auto-populated date in which, when it was printed off prior to filing the complaint, took the notice from October to February. Then that notice, when it was printed off, counsel who sent the notice just automatically signed it. No intent to deceive the court at all, just it was an automatic thing that he did. That issue was disclosed to opposing counsel prior to the hearing that ultimately involved the case, which was that was dismissed, and I believe from the record it was even stated to the court that that's what was going on. There was no intent to deceive, although a lot of hay has been made out of this purported deception. The letter also has another issue that is germane and the main issue of this appeal. The letter was sent to Mr. Michael Hambley, Chief Executive Officer of Alexian Village of Tennessee, and to Mr. Jeffrey Ott, President of Alexian Village of Tennessee. This case also has a companion case, which is on shortly after this on another issue involving a Rule 56 standard issue. But this notice was effectively copied and pasted from the previous suit that was sent. Therefore, they used the attorney that sent this document, this notice letter, just used the same format, same people they sent it to in the prior case. Unbeknownst to the attorney at the time, those 2 officers no longer worked for Alexian. Ultimately, the case was argued that it was sent to the wrong person in violation of the strict compliance of Section 1 as found under Martin v. Rolling Hills. Case also cited defendant cited a number of other cases involved with why this case should be dismissed, of which we have the Runyon's case, Myers and Foster, Brighthup, and Webb, all the typical players that we look at whenever we're dealing with 121 issues, which I know this panel is very aware of given the number that come before y'all. However, each of these cases can be distinguished in this instance. Runyon, notice was sent to the wrong hospital. That's not the issue here. The address was, the notice was sent to the address as published on the Tennessee Department of Health's website. Myers and Foster, those two cases involved filing of initial complaint, subsequent dismissal, and then prior to refiling the complaint, the parties did not resend the notice. So we feel that those cases do not apply. Brighthook involved a 121 letter going to the wrong address. Webb is where we get closest with this particular case. In Webb, just to refresh your memory, notice was sent to 5 individuals in that case. One of them, the closest letter that was analyzed, was sent to a Miss Pamela Bishop without identifying whether she was a doctor, administrator. It was just Pamela Bishop, and under it was Tribeca. That is it. When analyzing that case, the case was ultimately dismissed because Section 1 was not strictly followed. In fact, if you look at the language, they appeared to make every attempt to make that notice valid. The Court of Appeals really did bend over backwards to take a close look at it and say, all right, who was this supposed to go to? Who was it actually sent to? And do we have a violation? And while the defense would like you to look at it as a 2-element test established by Webb, in which they look at who it was sent to and who's identified in the body as to whom it's being sent. I remind the court that 121 doesn't say that you have to send it to the person and then identify that person in the body. In fact, I don't think it gives you any direction at all other than you need to send it to the proper party under A1 big A, which is the strict compliance factor. Here the court looked at it and said to Pamela Bishop, and they rejected that as the proper party, as they quote, because it failed to identify her as the administrator, because she was also a doctor there. Didn't know if it was being sent to her in her capacity as a physician or as an administrator. So since they couldn't determine who it was being sent to, because, as the court said in Webb, they failed to identify Ms. Bishop as an administrator, they went on to the second standard that you look at, second, instead of it being an element, maybe a factor that you would consider, in which did they identify the party in the body as of the notice letter as to whom notice was being sent. As you know, many of these notice letters fail because the notice letters simply say it's being sent to you. And that we also have in this case. The body of the notice letter didn't specifically identify the person. However, the plaintiffs argue that because they did identify the officers, or at least the roles of officer, to the agents of Alexian Village, that we satisfy that standard under Webb, because Webb seems to imply that you need to identify not just the name of person you're sending it to in these situations when it's not clear from the overall letter, but also the title of the person. And that was identified here. Plaintiffs concede that they're no longer officers. It's not a question before the court. It's not a question below the trial court. The question is sending it to 2 individuals in their capacities as CEO and president enough to satisfy the statute under strict compliance? The next standard, we discuss waiver, and having considered that argument more.
Excuse me for interrupting,
Yes,
counsel. It's my understanding, was there an amended complaint filed in this case?
Yes, there was, Your Honor.
And attached to the amended complaint were these same copies or notices attached to that amended complaint?
The notice itself is the proper, now once again, word for word, the only thing that was changed in the amended complaint was because it had an auto-populated date of February, the amendment went back to redate it as the proper date in which it was sent, attempting to take it back to what it originally was. And once again, we submit not a single word of the body of the notice letter was changed. It's the same notice letter, same Word document that was used. The only thing that changed was that auto-populated date at the top that got corrected. which leads to the, as a side note, leads to the second discussion, or the discussion we had with opposing counsel prior to the hearing in disclosing that. She had also identified that there was still a problem, even if we acknowledged the signature was not the same, and it's not. It was just signed. He just did it out of habit. Corrected date, but the notice is the same. Counsel directed us to our affidavit, in which the affidavit that was submitted under the first and second amended complaints refers to this as this is the notice letter that was sent. And technically, that affidavit would have been invalid, according to defense argument, and plaintiff lends some credence to it because we changed that document. We can't use the same affidavit identifying that document as the document that was sent, and then substitute with a different document because it's now referring technically to a different document. And so we would have needed to amend the affidavit, arguably under that. I think this is getting to losing the forest too much for the trees, respectfully, because the body of the notice, what was sent to the doctors, never changed in any version that was submitted. The only thing that was changed was the date and the addition of a signature. That's it. The notice was the notice. And if we start getting into that consideration, the statute isn't clear. Do we send the document that was actually sent to the plaintiffs, to the defendants? No, that's impossible. They're in possession of it. So is it a copy of it? Yes, that's been established to be perfectly fine in the past. What about the original document upon which that document was created? Is that not the same thing, essentially? The whole point is to make sure that we establish that notice is sent. And the defendants were able to find the notice that was actually sent, and once again, they match up. Only thing that was different was the signature and the date at the top. Are we going to find another way to penalize plaintiffs for minutia such as that is not intended to deceive, not intended to create any disillusionment with the court that we're trying to mislead them? I know we're going into the extra time, but I do want to say that the waiver provision, unless your clerks can find a good reason to keep that proceeding.
Okay, but do it very quickly because your time is up. So.
The next part that was brought up by the defendants in their brief involves failure to name the claimant. Now, this issue is before the Supreme Court, was argued on February 12th this year about who the claimant was as it's sent in the notice. In that case, it's Denson X. Real v. Methodist Medical Center, and an opinion hasn't come out on that. However, 121A2B doesn't go into how the claimant needs to be named or where. Accordingly, the plaintiff wants you to look at, believe it or not, a holographic will statute, 32-1-105, that says that a holographic will must be signed by the person to sign it. In 1957, in Henry...
Counsel?
Yes.
Your time's here.
Okay.
We'll hear from the appellee. You still have your 4 minutes for rebuttal.
Yes, thank you.
Would you pull the microphone down just a little bit, Kim? Thank you.
Can you hear me? Good morning. Again, I'm Bree Stewart. I'm here on behalf of the appellee, which is Alexian Village of Tennessee. This is a 2023 case involving care, which was given at Alexian's facility to Susan Anderson. So, of course, it's a healthcare liability action, which requires a notice of intent under 2926-121. And our argument is principally directed to the language in 2926-121A, which requires that a notice be sent pre-suit at least 60 days to a healthcare provider, to each healthcare provider who will be a named defendant. So in this case, the notice letter was addressed to, I think it is undisputed, to former officers of Alexian Village of Tennessee. It was sent only to Alexian Village of Tennessee's business address. It was not sent to Alexian Village of Tennessee's registered agent for service of process. I would note that under the statute, both of those notices are required. But to the extent that we are assuming that just the notice to the business address is sufficient to satisfy the statute's requirements, our principal argument is that this notice letter was addressed to Michael Hambley, CEO, Alexian Village of Tennessee, and Jeffrey Ott, President, Alexian Village of Tennessee. The body of the letter goes on to state, "Dear Messrs. Hambley and Ott, we are writing to notify you of a potential medical negligence action against you." Nowhere in the notice does it state that the medical negligence action is against Alexian or against any of Alexian's current or former healthcare providers. Mr. Hambley and Mr. Ott, of course, are not medical providers. They are not clinical, and neither of them had been associated with Alexian for at least 5 years, and this is, of course, undisputed. So in support of its ruling, the court made the following findings of fact, which, as we've set forth in our brief, are entitled to de novo review with a presumption of correctness. That there is no dispute that the address is Alexian's business address, that Hambley and Ott are not defendants in this case, and that neither Hambley nor Ott have been employed by or affiliated with Alexian for at least 5 years. So we, of course, filed our motion to dismiss and made these arguments. I think it is clear under all of the jurisprudence that considers this issue that plaintiffs must strictly comply with 121A and must address their notice to each healthcare provider who will be a named defendant. Mr. Hambley and Mr. Ott are not named defendants in this case and could not, by definition, have been named defendants in this case. So I think that if you look at Webb versus Trevecca, this is the closest case to resembling this particular set of facts. And I think that the Court of Appeals in that case found 3 dispositive issues. Well, really 2. Number 1, the notice in that case, which was addressed to the administrator, Pamela Bishop, not a clinical person, not a doctor, as Mr. Thomas just said, just the administrator, and she was the current administrator of the facility. This is the person who is in charge of administering the care that is given at the facility. It was addressed to her, and it said, please accept this as written notice of a potential claim. So the Court of Appeals said that the notice failed to identify the facility administrator. All it said was Pamela Bishop, Trevecca Center for Rehabilitation and Healing. And also, it failed to indicate that the plaintiff was asserting a claim against the facility. It didn't say either way. In this case, we have a letter that was not addressed to any person who was currently at the facility. So we are even further out from the facts in Webb as far as compliance. And the letter went so far as to state that the claim was against you, Messrs. Hambley and Ott, not Alexian, not any nurse at Alexian, not any current officer of Alexian. It said you, Messrs. Hambley and Ott. So if we're
Did
looking...
anything in the body of the letter mention Alexian or any of the service providers?
The letter itself just says that the lawsuit, the medical negligence claim, is being asserted against you. And
There's nothing, and then there's nothing in the body that says Alexian or, okay.
I mean, I think that,
And I'm sure we have it and we can look at it.
I do not think that, I mean, it just says below is a listing of the information required by 121, the patient and claimant, the address of the attorney, and HIPAA compliant medical authorization. It doesn't say anything about Alexian at all. It doesn't say anything about her care at Alexian at all. You know, some notice letters will say, and because I represent medical malpractice insurers regularly, a lot of these letters will say, this is because of her care during this
I'm sorry, it says against you, and what was the last part you,
I'm adding Messrs. Hambley and Ott to that because right above that it says, "Dear Messrs. Hambley and Ott."
yeah, but it doesn't say that right there, does it?
Right, but it says, "Dear Messrs. Hambley and Ott, please be advised that I am the attorney representing Susan B. Anderson. Through me, she is asserting a potential claim for medical negligence against you." That's the entire
Okay.
sentence. So with respect to the two dispositive issues in the web, the two things that the court based its ruling on, I think that it is clear that these facts are even less compliant with 121A's specific statement that any notice needs to be directed to any healthcare provider who will be a named defendant. And I'll point the court to Petty versus Burns, which is another case which was not mentioned by Mr. Thomas and not quoted in the brief. It is a very similar set of facts.
I'm sorry, it's not in your brief?
It's not in their brief, it's in mine.
Is it in yours? Okay.
And it is in my briefing below also. But in that case, this is a claim that was directed against a physician, Robert Burns, MD. And then the claimant went on to sue that physician's eponymous medical practice that was Robert M. Burns, MD, PC, the entity. And even though Dr. Burns was the owner of the practice, the registered agent, they got the right business address, the Court of Appeals said because you did not direct that notice to the entity as opposed to the registered agent and owner, that also did not strictly comply with 2926, 121A. Yes, sorry. I think that with respect to the other cases, there are a bunch of cases, Shockley, Runyons, where we have these notice letters that are directed to the wrong entity. They essentially are misnomer cases. I think that Shockley, we are addressing the notice to a foundation rather than a healthcare provider. And despite the fact that the NOI was set to the entity's correct business address and registered agent, because they were addressed to that different entity, that was not compliant with the statute. I also want to point out because, a lot has been made of the fact that, okay, well, we are addressing the former officers. We clearly meant to address our notice to the current officers, and this was just a mistake. Well, the same mistake was made in Runyons. And in that case, I think it's a Supreme Court case, held that addressing the notice to a former name of the exact same hospital and sending the notice to the hospital's current business address and correct registered agent, because we're naming a former entity that is no longer the correct person to address here, that also did not satisfy the strict compliance requirement of addressing the notice to the healthcare provider who will be named agent. It's the same thing here. If we really wanted to address the notice to the hospital through its officers, it would have taken a 5-second Google search to figure out who those officers were. All we had to do when we got this notice of intent, and the first time the facility had the notice of intent was found the notice of intent was after the complaint was filed. I mean, I literally Googled these two people and Alexian and popped up articles immediately showing that both of them had been gone for years.
Let's assume that the letters had been sent to the current CEO and the current president, but still contained the language that you read, suit against you. Would that be sufficient notice?
No, Your Honor, I think under Webb it wouldn't.
So you've got to say, we're sending it to the president of this entity. It's clear it's being sent to him in his capacity as president or CEO, whichever one it was, of the entity. But unless you say the suit is against the entity, you say the case says it's not sufficient.
I mean, I do think that Webb stands for the proposition that unless you say that the lawsuit is directed to the entity, or at least have some other indicia within the letter that it is directed against the entity, that is not compliant. So I think under the finding in Webb, again, one of the two dispositive
Was the president a healthcare provider?
I'm sorry,
Was the president a healthcare provider?
was he? I'm sorry, you're talking about Sir,
Either one of them. The former, okay. And the same question for the former or current CEO. Were they a healthcare provider?
I don't believe so.
I don't believe so. I doubt it, since what you said, that they're administrators. So if a letter is sent to the president of X company, I'm trying to understand why that's not notice to the company.
So I think that the notice must clearly identify whose care is at issue.
Well, if it's sent it to the president, this individual in the capacity as president, you don't think that's, and you say Webb support your position?
Yes, I do, and I mean,
I hope I wasn't on Webb, I wonder.
I'm sorry?
I said I was just wondering if I was on Webb or not.
I'm not positive, but anyway, I do think that because this letter says she's asserting a potential claim for medical negligence against you, certainly that
Against
would be
you.
confusing to anybody.
Against, well, there's only one president of the corporation.
Yes. So I do.
So it's not really against anybody.
I'm sorry.
It couldn't be really against anybody.
No, but I think the plain language of this letter says it is against Messrs. Stanley and Ott. And it would.
But it's addressed to them. It doesn't say you and then their names.
Sure, but it would have been easy to substitute you for Alexian or Alexian Village of Tennessee. I think our principal argument is based on the fact that this letter is essentially misleading and confusing at the very least. And so I think under the tenets of Webb, it does not strictly apply to this situation.
Okay, thank you. We'll hear from the appellant rebuttal.
I'm sorry, did I miss that?
Testing.
Thank you. We could hear both of you anyway. This is-
Real quick, I just looked up the Patey case that was mentioned by counsel a second ago. That involved a case that was sent to a doctor and his agents and employees. Then ultimately, when the case was filed, a new doctor was added in addition to the specifically named doctor, and they found that it was invalid as to the unnamed doctor. So I don't know where that applies in this case. I might be wrong. I just read it real quick, but that's what I took from it. Next, as to your question, Your Honor, the Trivecca case said, however, the Webb court specifically found that the, quote, letter made no mention of Ms. Bishop's role as administrator. And that was the key fact that was taken in Webb before it went into looking into the body. So the fact that the administrator was identified as such appears to be a key factor that the Webb court considered and that we ask for your honors to consider as well when deciding this case. Getting back to the additional issue that was brought up in the reply brief with respect to failure to name the claimant. That issue is still under consideration by the Supreme Court. Their father died, wrongful death action was brought on behalf of the minor children. However, when the notice letter was sent, it was sent by the mother, who was not the legal guardian. So an issue of whether the claimant was
In Denson,
in Denson.
I think it was mother and grandmother.
Mother and grandmother. I apologize for
I
that.
might have written that one.
I was reading it, and then I watched refreshed myself with the appellate argument, or the Supreme Court argument. But since you bring that up, kind of mentioned that, I did notice that Justice Campbell in that case specifically asked who signed the HIPAA release. And that appeared to be at least worthy of consideration. In this case, the notice that was sent was, we're sending it on behalf of Susan Anderson, who we all knew prior to was the ward, had a conservatorship appointed over her. And therein, the HIPAA, the 121 letter didn't identify the conservator in the body of the 121 letter. However, she was clearly identified when she signed the HIPAA release, in that she signed it in her capacity as conservator. So that's where we get to this Henry Jones case, which is 314 Southwest 2D 39, and the key part says there, when reading the will statute, the statute is not necessary to its validity that a testator's name appear at the end of a holographic will. It is sufficient that his name is subscribed anywhere in the will. And we ask that that application be made in this case. 121, does it say where the claimant need to be identified? Yes, it would be cleaner if she was identified right there in the 121 letter. However, we're asking, and this is unique, we're asking for the HIPAA release to be considered overall as part of the 121 letter in identifying the claimant. Now, this court has considered and rejected on several times that a defective HIPAA release be complemented by a 121 letter. But since the HIPAA release is governed by federal law and not state law, that's not a proper application, and this court has said that repeatedly. We're asking for the reverse, that the HIPAA letter, that the notice letter be complemented by the HIPAA letter, since it identifies the claimant there in the HIPAA letter as the proper party. And I'm unaware of any consideration by this court considering that reverse argument combined with any law that would prevent that application, specifically since 121 specifically brings in the HIPAA release as part of the 121 notice letter, with the exceptions of Wentzler VU and Hayward. So unless your honors have any more questions, I thank you for your consideration.
I hear none. Thank you.
Thank you.
We appreciate your briefs and your arguments in this case, and I understand we'll be here again for the next one. Call the next case, please.
All right, we have a moment to set up.
The easel.
Yes.